Hello friends, my name is Karun Nagpal and I'm an insolvency professional. In this video, we will talk about the pre-packaged insolvency resolution process. So recently, government through an ordinance has brought in this pre-pack insolvency resolution process under IBC. So what it is, in this video, we will talk about that and how this process is going to impact the MSME sector and most of the moribund companies in India who are suffering due to the pandemic. So pre-pack insolvency is very similar to the CIRP process. If you know the CIRP process already, so CD has to lose the control. So unlike CIRP, the difference in this process is that CD will keep the control of the business and the creditor will control and take most of the decisions, and the IRP or resolution professional IP would be acting as a supervisor or will be checking the compliances of the code. So it is basically a formal and informal blend of the process, because everything has to be discussed upfront before filing an application to NCLT, and base resolution plan has to be prepared by the CD, whether by itself or by taking help of other entities whosoever are interested in the CD's business. So up to a certain point, like initial talks with the financial creditor and the management of the CD will decide and pass the special resolution, and the directors agree, and talks with the financial creditors will be outside the court, and thereafter when they are ready will file an application to the NCLT. So application with the base resolution plan, in case FCs are satisfied, then the matter get resolved. In case FCs are not satisfied with the base resolution plan, then they will invite application from the outside parties, and the existing promoter may lose the control because they will have to compete. So there is a very good concept used in this process, which is Swiss challenge. So the base resolution plan has to compete with the bidders, and they will file an application, new fresh resolution plan, and those plan will compete and the best among them will be chosen. So one chance here the court will give to the corporate debtor, and in case corporate debtor is unable to compete with the bidders, so it will lose the control of their control over the CD. Similar to CIRP, 66% majority for the financial creditor is required for most of the decisions, and in this case the possibility of liquidation, because liquidation is very dangerous to the economy, because in case of liquidation the employees lose their job, workers have to go home. So government do not want that the companies get liquidated. So in this case, if the base resolution do not meet the expectation of the financial creditors, then somebody else will pitch in and they will come up with the new plan so that the matter gets resolved. So in case no bidder is there or no application, so financial creditor would have to choose, either they agree with the base resolution plan or they wanted to go with the CIRP process. So after the PPIRP, the financial creditor, if they fall into the 1 CR, because 1 CR is the current limit, they can go to the CIRP process. So this process is time bound again, similar to CIRP, and the government has reduced the number of days. Only 90 days has been given to complete the process, and 30 days for the NCLT to approve or reject the plan. Again, checks are there in the code. Chapter 3A has been added. So at several places, responsibility of the financial creditor for the IP, who will act as an RP in this process, has been fixed, and currently this process is applicable only for those entities who have made the default above 10 lakh, and only for MSME entities. MSME defined under Section 7 of MSME Act for the investment in plant and machinery, and as per those investment there is a criteria for small, medium and micro entities. So default, as I say, is to be 10 lakh, unlike 1 crore currently in the CIRP process. So earlier it used to have been 1 lakh. So due to the pandemic, government has kept it to 1 CR. So basic structure is creditor would be controlling the business, but they will not be doing the day-to-day activities. The debtor itself will be running the business, but the creditor will be taking the major decision, and the creditor will be taking help of the RP, the IP, who would be acting as a supervisor, or who would be confirming the task of them, whether the debtors are performing their duties, whether they are not doing any fraud. So this thing RP has to confirm. Again, moratorium is there in this process. So once the application get approved, so moratorium will be applicable, and this plan would be binding in case similar to CIRP. In case RP find any fraudulent or extortionate transaction, he can report that to the NCLT, and all those promoters who are ineligible to file a resolution plan under section 29, they are not entitled to file an application under this chapter. So they are not entitled to file an application for Prepack insolvency resolution process. So let me compare, friends. If you look at the screen, the difference between CIRP and the PIRP process. Before we begin with the code, let us quickly go through the difference between these two processes. The objective is the same, to resolve the insolvency and through a resolution plan. It is not a recovery legislation, so our objective is to resolve the insolvency. Applicability would be both on companies as well as LLP. Default in case of CIRP it is 1 CR, and in case of PPIRP it is minimum 10 lakh. So above 10 lakh you can go and file an application, provided you fall under an MSME sector. Here the process can be initiated by FC, the CIRP process, or OC under section 8, FC under section 7, or CD under section 10. Whereas in PPIRP only CD can initiate the process, and the consent of 66% of unrelated FCs are required. Management here, in case of CIRP, the IP would be managing and creditor would be controlling. In case of PPIRP, the possession will remain with the CD, the management of the CD will be active, and the creditor will be controlling the decisions, major decisions. In case of CIRP, first of all, IRP is proposed by the applicant, whether it is FC, OC or CD. Then once the COC is constituted, whether the IRP get confirmed as an RP or a new RP is appointed, and this person, IRP or RP, has to manage the affairs of the CD and conduct the entire process. However, in case of PPIRP, RP is approved with the consent of unrelated FCs. 66% FCs approve, and 10% can propose the name of the RP, and 66% of the financial creditor approve the appointment of RP. Claim collation, it is the responsibility of IRP in case of CIRP. However, in case of PPIRP, CD will do the claim collation, and RP will check and update the list of the claims as and when he find the new claimants. Information memorandum, in case CIRP is prepared by RP, in case of PPIRP is prepared by CD and is finalized by the RP. Moratorium is limited in PPIRP process. However, in case of CIRP, it is as per section 14. So it says no suit or proceeding can be initiated, or supply of essential services. So in case of PPIRP, it is for a limited period when the application get admitted. Interim finance is available on both the cases. Avoidance transaction, RP has to file and valuation in both the cases, two valuers have to be appointed. Then friends, CIRP cost. In case of CIRP, so the cost to run the business gets included in the CIRP cost. However, in case of PPIRP, since the CD itself is managing the business, so the cost of running the business is not included. Invitation to resolution plan, CIRP is a public process, and in case of pre-packaged, the first right is of the promoter, and then thereafter Swiss challenge. We will talk about the Swiss challenge. The bidders are given opportunity to compete with the base resolution plan. So how it works, we will talk about that later. And ineligibility is there in both the cases. In case promoter is a willful defaulter or is of unsound mind or has committed any default. Early closure of the process. So section 12A is there on the request of the applicant with 90% of the majority of the financial creditor. Application can be withdrawn, and in case of PPIRP, 66% of the vote share is required, or suo motu COC may also resolve that we do not wish to continue with the PPIRP, and they can proceed with the CIRP. Approval of resolution plan, 66% voting shares are required. Termination is not allowed in case of CIRP, or however in case of PPIRP, closure can be done without the outcome, and the process can be moved to the CIRP or liquidation in case of fraudulent activities has been detected. So liquidation can be initiated. Binding outcome resolution plan is binding in both the cases. Regulatory benefits are there. Post resolution clean slate, so whatever the CD has done in the past, it would be applicable only to the erstwhile promoter or director, the penalties or prosecution, and the resolution applicant will not have to face that the trouble. The role of IP is more, as you can see in CIRP, because he has to take the charge of the company, and in case of PPIRP, he just has to oversee and conduct the meeting of COC, invite the resolution plan and all. So relatively it is less. Timeline in case of CIRP is 180 days. In case of PPIRP, it is 90 days plus 30 days for the adjudicating authority to approve the plan. Cooling off period between two CIRPs is 12 months. In case of two pre-packs, it is 3 years. So since this has just started, this 3 years cooling period will not be applicable, because all of the eligible entity can proceed and file the application. Now friends, let us talk about the PPIRP process in detail. Chapter 3A has been added in the IBC, and it starts with section 54A. So let us friend now start with section 54A. You will have more clarity over the PPIRP process. Application for initiating the pre-pack insolvency resolution process may be made in respect of corporate debtor classified as MSME. Now MSME, as defined under section 7 of MSME Act, MSME Act 2006. So that there is a criteria based upon investment in plant and machinery. Based upon that criteria, whether it is a manufacturing entity, whether it is manufacturing goods or providing services, so there are threshold for classification of MSME. For up to 25 lakh investment, one is classified as micro. From 25 lakh to 5 crore, it is small entity, and 5 crore to 10 crore, it is a medium entity if it is in the production of goods. In case of services, micro is 10 lakh, small is 10 lakh to 2 crore, and medium entities are 2 crore to 5 crore. That is investment in plant and machinery, not the turnover of an entity. So now, without prejudice to subsection 1, so that means only an MSME can file an application. Application for initiation of pre-pack Insolvency process may be made in respect of corporate debtor who has committed a default under Section 4. So Section 4 talk about default. In case it has committed any default, MSME entity can go to NCLT and file an application, provided that. So some conditions are to be satisfied before entity can go to NCLT and file an application, Prepack insolvency application. So it has not completed the Prepack insolvency process during the period of 3 years preceding the initiation date. So this will be not applicable for all of the entity going for this application because it has just started. So after 3 years, if you have filed one application today, you cannot file another application next year or after couple of years. There has to be 3 years gap in between. It is not undergoing CIRP. If some application is already been filed under the CIRP or already going on, pending applications are there under CIRP with NCLT, so this process cannot be initiated. No order of liquidation under Section 33. If under Section 33 NCLT has passed the liquidation order, then also Prepack insolvency resolution process is not possible, and it is eligible to submit the resolution plan under 29A. Section 29A talks about the ineligibility, undischarged insolvent, willful defaulter, whether somebody has committed crime, so those all are ineligible to submit a resolution plan under 29A. So if entity is not eligible to file a 29A resolution plan and is disqualified, so it cannot file an application for PPIRP. Then clause E says the financial creditor not being related party. Here it is written that such number, so it is 10% of the financial creditor will propose the name of the IP who will become the RP, and it should be approved by not less than 66%. 66% of the financial creditor will approve the appointment of RP who will act as an RP of the PPIRP. Provided that where corporate debtor does not have financial creditor, now if same as with the case of CIRP, if there were no financial creditor, the 18 largest operational creditor and one representative from employee and one representative from workman become the committee of creditor. Now again, in this case, in case of PPIRP, if there are no financial creditor, the proposal and approval under the clause shall be provided in the manner specified. So the manner has been specified, which says 10 largest operational creditor and one representative from workman and one from the employees. So total will be 12 members will constitute the committee of creditor. Then clause F talks about that the directors or the partners, the director or the partner with majority, here it is 51%. So they may file a declaration. Declaration form is there, the form number P6. Form P6, in form P6 they have to file a declaration that they will complete the process within 90 days. So this process has to be completed in 90 days. That is why they have to file a declaration. The directors or partner in case of LLP will file a declaration which says that they will complete the process within 90 days, and this process has not been initiated to defraud any person. They will have to file a declaration and they have to submit the name of the insolvency professional which is proposed and approved by the financial creditors. Then clause G talks about the special resolution. So before directors go ahead and file the PPIRP application, a special resolution is required from the shareholders, or in case of LLP at least 3/4 of the majority. So 3/4 of the total number of shareholders or partners in case of LLP should agree for filing of application under PPIRP. Then subsection 3 talks about corporate debtor shall obtain an approval from the financial creditor. An approval is required from the financial creditor with 66% majority. So one cannot go and file an application without the consent of the financial creditor. So corporate debtor, if it is an MSME, cannot by itself go to NCLT and file an application. It requires the approval from the financial creditor for appointment of RP as well as for initiating the process under the PPIRP. In case the corporate debtor does not have the financial creditor, what will happen in case corporate debtor do not have the financial creditor or all the financial creditor are related party? So manner has been provided. Then in that case the operational creditor will become the COC, and 10 of the largest operational creditor plus one representative from employee and one representative from workman will become the member of committee of creditor. Subsection 4 says prior to seeking approval from financial creditor. So before filing an application we need the approval from financial creditor. It is clear because it is clearly written in subsection 3. So corporate debtor has to provide some documents to the financial creditor so that the financial creditor in their meeting decide that the CD can go and file application. So these documents are, they will have to give a declaration referred above. What is declaration says? That this process should be completed in 90 days. It has not been initiated to defraud any person, and the insolvency professional approved by the financial creditor is appointed. And a special resolution. So we talked about subsection 2. Special resolution is required by the shareholders or partner of LLP. And a base resolution plan. What is base resolution plan? Which confirm the requirement of section 54. So we will talk about that. This is basically a restructuring plan or repayment plan which the CD proposed to the financial creditor. So this plan will be prepared by the corporate debtor and will present it to the RP, and RP will check that plan and confirm that plan. So before initiating the process, this base resolution plan CD has to prepare and submit to the financial creditor, and such other documents as may be specified. These may include previous year financial statements and the latest financial statement up to the date of declaration. Now friends, section 54B talks about the duties of the resolution professional. So what would be the duty of resolution professional before initiating the process? Before initiating the process, what would be the duty of resolution professional? So the IP who is proposed, who will propose 10% of the financial creditor will propose the name of the IP, and 66% of the financial creditor will approve the appointment of RP. So he will have the following duties. First one is to prepare a report in such format as may be specified. So he will have to prepare a report in form P8. P8 form is there. In that he will have to prepare a report which says that the base resolution plans, the base plan which has been prepared by the CD meets the requirement of subsection 4 or section 54A. So what is subsection 4? That a declaration has been filed by the directors or partners in case of LLP that they will complete the process in 90 days, and they have not initiated this process to defraud anybody, and IP who is approved by the financial creditor is appointed, and a special resolution has been passed with 3/4 majority in case of LLP, and the base resolution plan meet the requirement under section 54K. We will talk about that. And such other information is the financial statements for preceding 2 years or the latest financial statement as on the date of declaration. So this RP has to confirm that the plan and all these requirements are fulfilled, and he has to file such other reports and other documents. So he will have to do the reporting to the board and also to the agency. So they will ask for the monthly reporting and such other duties as may be specified. Subsection 2 of section 54B talks about the duties cease to exist. When it will cease to exist? If the time period has expired. That means 90 days when we say 90 days to complete the process, in case 90 days expired, so the above duties of the IRP will cease to exist. Or the application is admitted or rejected. In case the application is admitted, so he must have complied with all his duties, so it will cease to exist. The fees payable to IRP. Now the fees will be shall form part of the Prepack insolvency resolution process cost. So similar to CIRP, the fees payable to IP will be the part of this Prepack insolvency process cost. Then section 54C. Now under section 54C, the CD will file an application to initiate the process, and application has to be filed with the adjudicating authority. So it will file an application with the adjudicating authority for initiating the process, and shall be filed in such form. So the forms are there in the rules, and rupees 15,000 is the fees to file an application. In case of section 7 and 10, it is the fees is 20,000, here it is 15,000, and in case of section 9 it is just 2,000. Now the corporate applicant along with the application shall furnish, now along with the application which is to be filed to NCLT, a declaration. So declaration by the directors or promoters, majority directors, a special resolution with 3/4 majority, a special resolution in case of company, or 3/4 of the majority in case of LLP, a resolution, and the approval of financial creditor. So we have got the approval from financial creditor under section 54A4. We have provided them with all these documents, and we got the approval from the financial creditor. So this approval we have to file with the NCLT, and also the name and the consent of the RP. So in form 1, RP has to give his consent to be appointed as an RP of the process. So that has to be filed along with the application. Then friends, under clause C, a declaration regarding the existence of transaction. Now who will file the declaration? It is the directors or whosoever is filing the application on behalf of the CD. So they will give a declaration for the existence of transactions. These are the transactions, fraudulent, wrongful trading or extortionate transaction, like that. They will have to give the declaration. So in case later on it is found that they have filed this application to defraud others, so under section 54J, NCLT may order, and NCLT may pass on the entire control of the CD to the IP, to the RP. So and then RP has to manage the affairs, and the directors of the company will lose the control over the company. And the information relating to the books of accounts of the corporate debtor and such other documents as may be specified. So information regarding the document, so it will be books of accounts for 2 years, and the latest available financial statement to the date of declaration. So under section 54C, what we have to do? This is the important section. Under this section, the CD will file an application to adjudicating authority. It will take an application to adjudicating authority, pay 15,000 of fees, fill in the forms, attach all the disclosures. So first one is declaration, then second one is special resolution, third one is the approval of financial creditor, fourth one is the written consent of the RP, and another declaration from the directors that they have not done the activities, there are no avoidance transaction, they have not done any fraudulent or wrongful trading, and they will have to also attach the information relating to the books of accounts. That means the previous 2 years financial statement and the latest financial statement to the date financial statement. Now once the application is filed to adjudicating authority within 14 days of receipt either admit that application or reject the application. If the application is complete, they will admit the application, and in case the application is incomplete, they will give an opportunity to the applicant to rectify the defect, and 7 days will be given to the applicant, to the corporate debtor, to rectify the defect. In case they rectify the defect, application get admitted. On lapse of 7 days, application will get rejected. So the pre-pack insolvency resolution process shall commence from the date of admission of application under clause A of subsection 4. So this is the section where the application gets admitted. Now friends, moving on to section 54D. 54D talks about the time limit for completion of this process. Time limit is 120 days. If you can see, 120 days, but I said 90 days. So this 120 days include the time taken by the adjudicating authority. So for CD, it is just 90 days. So CD has to give the undertaking that it will complete the process, submit the plan in 90 days, and 120 days, additional 30 days for the adjudicating authority to either approve or reject the resolution plan. So resolution professional shall submit the resolution plan approved by the committee of creditor. So committee of creditor will approve the resolution plan, and the RP shall submit the resolution plan to the NCLT. And there are two sections, subsection 4 or subsection 12 of section 54K. Under subsection 4, it is the base resolution plan, and under subsection 12, it is the best plan. So once this CD is unable to meet the requirement of the committee of creditor or unable to convince with its base resolution plan, the COC may decide to invite the outside resolution applicant, and under the Swiss challenge, they will submit their resolution plan, and those resolution plan will have to compete with the base resolution plan of the CD, and whosoever has the best resolution plan will get selected. So in case of subsection 4, it is the base resolution plan by the CD, and under subsection 12, it is the best resolution plan. So whichever plan gets selected, resolution professional has to file that plan, approved resolution plan, with the adjudicating authority within a period of 90 days from the pre-packed insolvency commencement date. That means within 90 days they have to approve the plan and have to submit to the NCLT. So in case there is no resolution plan, that means CD has submitted the resolution plan, but there is no outside party who has come up with the resolution plan, and the time limit get expired, this 90 days gets expired, then also the RP shall go to the NCLT and file an application to the adjudicating authority for termination of the insolvency resolution process. So after 90 days, the process will get terminated. Then friends, we have section 54E. It talks about declaration of moratorium. So adjudicating authority, when the CD will file an application to adjudicating authority and the application gets admitted, so adjudicating authority will declare a moratorium and cause a public announcement. So let us talk about section 54E. The application which CD has filed to the adjudicating authority gets admitted. So the adjudicating authority shall declare a moratorium. Moratorium means similar to section 14. Here also all the application, all the pending litigation suits will come to an halt, and the supply of essential services will continue. So this section will apply to the PPIRP application also, and the appoint the resolution applicant. So the resolution applicant which has been proposed by the FCs and later on approved by the FCs, and thereafter the CD will, along with the application, give the consent of this RP to NCLT, and that RP will get appointed. And it says as named in the application. So the RP who has been approved by the FCs will be named in the application, and that RP will get appointed only if there is no disciplinary proceedings. In case of disciplinary proceedings, so NCLT will decide from its list and will appoint someone else, and thereafter cause a public announcement. So this is the responsibility of RP. RP has to within 2 days. Here it is 2 days. It says immediately after his appointment. So 2 days. Here they have reduced from 3. In CIRP there are 3 days. So in this case it is only just 2 days. So within 2 days the RP has to give a public announcement. And the order of moratorium shall have effect from the date of such order till the Prepack insolvency resolution process come to an end. So moratorium will start from this admission date and will end on the completion date. That means after expiry of 90 days. So in case the resolution plan is submitted before 90 days, then also the moratorium will come to an end. Then friends, we have section 54F. It talks about duty and power of resolution professional. So resolution professional, similar to CIRP, will have some powers and some responsibilities. So let us talk about the duties. So RP has to confirm the list of the claim. List of all the claims will be submitted by the corporate debtor, and RP role is to just confirm the list and update the list. And he will have to inform the creditor regarding their claims and get the confirmation, update the list as and when he gets the claims, additional claims, he will have to update, and update the committee of creditor also in case he gets any new financial creditor. Monitor the management of affairs of the CD. He do not have to manage the affairs of the CD, he just have to monitor here. In case of CIRP, he has to take charge and do everything, control the management of the CD. Now here he just has to monitor so that there is no fraudulent activity, and inform the committee of creditor in the event of breach of any obligation by board of directors. So in case of any breach of obligations by the board of director, the RP has to inform the committee of creditor. Constitute committee of creditor, convene and attend all the meeting. He will have to act as a chairperson of the meeting, share the minutes of the meeting to the committee of members of the committee. First of all, constitute, then convene the meeting, attend all meeting, act as a chairperson, then send the minutes to all the participants of the meeting, prepare the information memorandum. Information memorandum will be based upon the preliminary report prepared by the CD. So CD will prepare the base resolution plan, base information memorandum, and RP will have to just update that information memorandum. So information memorandum, friends, if you are not aware of, is basically the information about the CD, its financial, everything, whether it is litigation, so that the resolution applicant can invest in the CD. So the purpose of the information memorandum used to be in CIRP to make the applicant aware of the CD, its financial positions, its activity, its worth, its customers, and all the details. So you can say it relate this information memorandum with the annual report of any organization. So here in case of PPIRP, it would be the responsibility of the CD to prepare the information memorandum, and RP will update the information memorandum as and when he get any other relevant information. Then similar to the CIRP process, RP has to file an application for avoidance transaction under chapter 3 of fraudulent wrongful transaction under chapter 6, and other duties as may be specified in under regulations. So these are basically the duties of the RP. And now let us talk about the powers of RP. So similar to the powers in CIRP, here also some powers are given. He can access the books of accounts, record and maintain. He can access the electronic records available with any information utility. He can access books of accounts available with the government authorities, statutory auditors or such other person, attend the meeting of member board of directors and the partners in case of LLP, appoint accountant, legal or other professional in such manner as may be specified, collect all information relating to assets and finances of the operations and frame an opinion on the existence of any avoidance of transactions. So if there are fraudulent, undervalued, extortionate, wrongful transactions, he will have to frame an opinion and have to file an application to NCLT. So he can take the business operation for previous 2 years, financial operations for 2 years, for identifying these kind of transaction, list of assets and liabilities or such other matters he may take into account. Take such other action as may be specified. So regulations will specify some other powers, so we'll talk about that. From the date of appointment of resolution professional, the financial institution maintaining the account of corporate debtor shall furnish all information relating to corporate debtor to the RP as and when required. So all the financial institution, whoever maintains the accounts of the CD, will provide information to the resolution professional. The personnel of corporate debtor, promoter. So under the CIRP section 19(2) application can be filed in case of non-cooperation by the management of the CD. Now also again in this section, personnel to extend support to the insolvency professional, to the resolution professional. In case they do not provide the support to the RP, he can file an application and section 19(2)(3) shall apply in this case also. Fees of the RP or any expense incurred shall be determined in such manner. So regulation will talk about that. It has to be approved by the through committee of creditors, similar to CIRP, or any expense which RP has incurred prior to constitution of COC. So COC will have to ratify that. Fees and expense shall be borne in such manner. So it will be borne by CD. So we will, in the regulation, we will talk about that, how the fees and expense of the resolution professional will be dealt. Section 54G talks about list of claim and preliminary information memorandum. So now CD, it is the responsibility of the CD to maintain the list of claims. So within 2 days of the pre-packed insolvency commencement date, submit to the RP. So once the CD file an application, then it gets approved. So within 2 days of its approval, it has to provide the list of claims. Now you will say that 2 days very less to prepare the list of claims and file it. So this process, collating all the claims, will be done beforehand and it will be available. So CD just have to provide those lists to the RP, and RP will update that list going forward. So list of claims CD will provide along with the details of respective creditors, their security interest and guarantees in case there are any guarantees. Also preliminary information memorandum containing the information relevant to formulating a resolution plan. So as I said that this information memorandum has all the details of the CD, so it will prepare and give it to the RP. Where any person has sustained any loss or damage as a consequence of omission. So in case the CD do not provide all the information and somebody sustain any loss or damage, so there is a very harsh penalty. So the promoter or the directors or any person authorized who is acting on behalf of CD shall be liable to pay compensation to every person who has sustained a loss. So section 77A talks about punishment for offences under PPIRP. So this is a newly added section and it says 3 to 5 years of imprisonment and 1 lakh to 1 crore of fine. So adjudicating authority may impose that. No person shall be liable under subsection 2 if it is without his knowledge. So if anybody is not the party to that default, so he will not be, obviously he will not be liable. Subject to section 54E, any person who sustained any loss or damage as a consequence of omission of any material information may move to court having jurisdiction. So he may file a suit, a separate proceeding for such loss or damage. So he is free to file any other application. He can move to any court and file application for compensation if somebody has sustained any loss. Section 54H talks about management of affairs of CD. Now who will manage the affairs of CD? It will be the CD itself. But in case CD do any fraudulent activity or the directors breach the trust, so in that case NCLT may order that the management will be taken care by the RP. So management of affairs of CD during the pre-pack process, the management of affairs of CD shall continue to vest in the board of directors. So board of director will, or the partners in case of LLP, will continue to manage the CD. The board of director or partners in case of LLP shall make every endeavor to protect and preserve. So here it is their responsibility to protect and preserve the value of the property of the CD as a going concern. And the promoter member personnel of the corporate debtor shall exercise and discharge their contractual and statutory rights and obligations in relation to corporate debtor, subject to the provision of this chapter and such other conditions as may restriction as may be prescribed. So rules have prescribed the restriction. We will talk about the PPIRP rules also later on. Then friends, section 54I, committee of creditor, the RP within 7 days. He will have 7 days to constitute the committee of creditor based upon the list of claim as provided by the CD, provided that the composition of committee of creditors shall be altered on the basis of updated claim. So first list of the creditors will be provided by the CD. Based upon that list, RP will constitute committee of creditor within 7 days. 7 days he will constitute COC, and then later on, as and when he gets the updated list of creditors, he will update the committee of the creditor, composition of committee of the creditor. First meeting of the committee of creditor will be held within 7 days of the constitution. That means 14 days. After 14 days of the insolvency commencement date, he will have to convene the first meeting. Then friends, provision of section 21 shall apply mutatis mutandis in this case also, and subsection 9 or 10 of 21, where 9 and 10 says that the COC can approach to the RP and ask for the details. So in this case, because CD and RP both are managing the affairs, and the business is in the control of CD, so that is why it says that CD and RP in case of only RP as written in section 21. Now friends, section 54J talks about the vesting of management of the corporate debtor with RP. So if the CD or its management or its directors are not performing in good faith, because now they have defaulted and the government has given them the opportunity to run the business, and still if they are violating and they are not acting in a transparent way, or they are not cooperating or doing some fraudulent activities or transaction, so COC with 66% majority may decide that they do not want the CD or its management to run the operation, and they want all the management to be passed on to the RP, and they may ask the RP to file an application to NCLT, and then NCLT may approve. So let's see what NCLT says. NCLT may order that the management of the corporate debtor shall vest with the RP. So what are those cases? So it has to be decided by the committee of creditor with 66% majority, and the RP shall proceed with the application to adjudicating authority, and if adjudicating authority is of the opinion that the affairs of the CD have been conducted in a fraudulent manner, there is some fraudulent activity or gross mismanagement of affairs, so it shall pass an order that the CD's management to be vested with RP. So RP will take the charge. Notwithstanding anything to the contrary contained in this chapter, the provision of subsection 214 is supply of essential services. Now 2 and 2A will apply, essential services will continue. Section 17 is the management of affairs of the CD by RP, and clause E to G of section 18, which talks about the custody and control of the CD's asset. So RP will take custody and control. Section 19 and 20, 19 talk about all the personnel to cooperate with the RP, and section 20 talks about the management of CD as a going concern. So RP will have to manage the CD as a going concern. And section 25 subsection 1 is to preserve and protect the assets of the CD, and clause A to C of and clause K of subsection 2 to section 25 says that RP can represent on behalf of CD and raise interim finance, etc. And section 28 says the approval of CD is required in case of certain activities such as change in the constitutional documents of the CD. So in those cases approval from COC is required. So all these sections shall mutatis mutandis apply to the proceeding under this chapter from the date of order. So once the order has been passed by NCLT, so all the powers which were there in the CIRP process will be applicable here with the RP. RP also will get all the powers which were there in the CIRP process. Then friends, moving further, section 54K talks about consideration and approval of resolution plan. Now the corporate debtor would have the resolution plan ready, because the base resolution plan has to be filed along with the application, and this resolution plan he will pass on to the RP within 2 days of the commencement date, and the RP shall present this, because within 7 days he has to constitute committee, and within next 7 days he has to convene the first meeting. It will provide this plan to the committee of creditor. Now committee of creditor will in its meeting decide whether to go with this plan or invite the additional plan. And committee of creditor may provide an opportunity to the corporate debtor to revise the base resolution plan. So under subsection 4 it may approve the base resolution plan or may go for the additional resolution plans from the fresh resolution applicants. So it will give an opportunity to the CD to revise the plan. Then friends, the resolution plan and base resolution plan submitted under this section shall conform to the requirement of subsection 1 and 2 of 30. Now section 31 talks about the eligibility criteria as defined under section 29A, whether the resolution applicant is qualified under 29A or not, and section 32 says that the resolution plan should provide for the PPIRP cost and the payment to the operational creditor as per the waterfall mechanism as defined under section 53(1). And the provision of subsection 1, it says that the provision of 1, 2 and 5 of 30 shall mutatis mutandis apply to the proceeding. Subsection 5 says that the applicant can attend the meeting of the committee of creditor where his plan is presented, and he will not have any right to vote in that meeting. The committee of creditor may approve the base resolution plan. Now the committee may approve the base resolution plan for submission to the adjudicating authority. So in case they agree with the base resolution plan, so what will happen, they will give an opportunity to the CD, and CD come up with the revised resolution plan, and they agree with that, they can approve that plan, provided that plan should not impair any claims owned by the corporate debtor to the operational creditor. So that should not impair any claims to the operational creditor. The claim of the operational creditor should be paid in full. Then only the base resolution plan can be considered and approved by the committee of creditor. So where the committee of creditor does not approve the base resolution plan, it can approve the revised plan. So the base resolution plan impairs any claim. So if the base resolution plan is not approved, or base resolution plan impairs the claim of the operational creditor, resolution professional shall invite the prospective resolution applicant. So he will make a public announcement and invite plans from the prospective resolution applicant to compete with the base resolution plan. So it is specified in the regulations with illustrations how this base resolution plan and the fresh plan will compete. This process is called Swiss challenge. We will talk about that later. And moving further, friends, subsection 6, the resolution applicant submitting the resolution plan pursuant to the invitation shall fulfill such criteria as may be laid down by the resolution professional with the approval of committee of creditors. So basis the scale of operation of the CD, or the size or complexity of operations, so they will make some criteria for the resolution applicant in terms of investment, or in terms of the sector. Suppose telecom industry or companies under this process, so they will invite the resolution only from that particular sector company. So that company should have experience or like that. So that will be decided in the meeting of committee of creditor, and the criteria will be laid down by the resolution professional. The resolution professional now shall provide to the resolution applicant. It will provide to the resolution applicant the evaluation of resolution plan. So the basis, so this is called the evaluation matrix, how your plan will be evaluated, and the relevant information referred to in section 29. So resolution applicant will have the information memorandum, because without information memorandum he will not be able to bid for that. So he would certainly require some information so that he can frame an opinion about investing in the CD, or he will be able to value the worth of the CD. So he would seek for this information, and the resolution professional shall provide this information to the resolution applicant. And resolution applicant has to comply with this section 29 requirements, which state that he will protect and preserve the intellectual property of the CD, and he will not divulge into any undue gain by use of this information. Subsection 8 says the resolution professional shall present to the committee of creditor for its evaluation the resolution plan which conform to the requirement under subsection 2 of section 30. So if the plan meets the criteria laid down under subsection 2 of 30, which says that the resolution plan should provide for the process cost, the Prepack insolvency resolution process cost, the operational creditor should be paid, and as per the section 53(1). So if the requirement of this section is complied with, he will provide all those resolution plan, and he will present it to the committee of creditor for evaluation. Now friends, the committee of creditors shall evaluate the resolution plan. So they would have the base resolution plan and the resolution plan presented by the RP, which he has collected through the resolution applicant, and select the resolution plan among them. So they will have to select the best resolution plan, where on the basis of such criteria, the committee of creditor decide that the resolution plan selected under subsection 9, here selected in this subsection, is significantly better than the base resolution plan. such resolution plan may be selected for approval under subsection 12. So what is significantly better, they will have to disclose upfront at the time of giving advertisement, or when the resolution applicant are filing their resolution plan, they will have to tell that this is the base resolution plan, and the next plan would have to be this particular percentage higher than the base plan. Say for example, base resolution plan bids for 100 crore of payment, and they have said that the significantly better plan should be at least 5% higher than the base resolution plan. Now plan which provides for 103 crore, which is not 5% more than the base resolution plan, will not be accepted because it is not significantly higher than the base plan. It should be at least 105 crore to become the significantly better plan, provided that the criteria laid down by the committee of creditor under this subsection shall subject to the condition as may be specified. So this has been specified in regulations. We will talk about that. When the resolution plan selected under subsection 9 is not considered for approval or does not fulfill the requirement of subsection 10, that means the resolution plan is not significantly better, it is 103 CR, then it shall compete with the base resolution plan in such manner and subject to such condition as may be specified. So under the regulation, friends, they have made the Swiss challenge. If it is not meeting the significantly better criteria, it can compete and it can come up with the next bid which is significantly better than the base resolution plan. So this is how the process will go. We will talk about this process in my next video during the regulations. So if next plan is not significantly, they will get an opportunity to revise the plan and make their plan significantly better than the base resolution plan, and their plan will get selected under section 12, subsection 12. The resolution plan selected for approval under subsection 10 and subsection 11, as the case may be approved by the committee of creditor for submission to adjudicating authority. So now a plan can be approved under subsection 12 or subsection 4, because 4 says that the base resolution plan can be approved by the COC if it do not impair any claims of the operational creditor. So if base resolution plan do not impair the claims and the COC agree, they can approve under section 4, else they can approve the significantly better plan under subsection 12. Provided that where the resolution plan selected for approval under subsection 11 is not approved by the committee of creditor. Now the plan may not be get approved by the committee of creditor. The resolution professional shall file an application for termination. So if base resolution plan is rejected by committee of creditor and then resolution professional invite the additional plan, and all those plans which he has got from the different resolution applicants also get rejected and COC do not approve any plan, so then resolution professional will file an application to the NCLT for the closure of this process. Now friends, the approval of resolution plan either under subsection 4 or 12, this is base resolution plan and this is significantly better plan, shall be made with a vote share of at least 66% of voting share. So COC in its meeting decide the feasibility and viability, decide that the plan comply with the requirement of 31 and 2, and they will approve the plan and they will make sure that the plan comply with the requirements as set out under section 53(1), the priority order, so that it should not impair the rights of the operational creditor. If it impairs, should be as per section 53(1), and the security interest of the secured creditor also taken into account, so that the secured financial creditor gets the payment as per the order defined under section 53. While considering the feasibility, if the COC finds that there is any impairment of the claims, their claims gets impaired, so COC may require the promoter to dilute their shareholding. So COC will dilute the shareholding of the promoter, and in case plan do not provide for any dilution, they will have to record the reason for the same in writing in their approval. So NCLT will ensure that this has been complied with. Resolution professional shall submit the resolution plan approved by the COC to the adjudicating authority. Two explanations have been added here. It has been clarified that the corporate debtor, being a resolution applicant, may submit the base resolution plan either individually or jointly. So before filing of applications also, CD may approach to some other company, and jointly with some other company, CD may come up with the base resolution plan. And explanation 2 says that subsection 4 and 14 claims shall be considered to be impaired where the resolution plan does not provide for full payment of the confirmed claim. So impairment will be in case the claims are not paid in full. So as per the list maintained by the resolution professional, whether that is for operational creditor or financial creditor. So as we have discussed that base resolution plan will be approved only if there is no impairment for operational creditor. However, the financial creditor can take the haircut. In case of the approval under subsection 12, resolution plan can be approved with the haircut for both financial and operational creditor, but it should comply with the requirement set out under section 32, which is the payment of PPIRP cost and the criteria laid down under section 53, the payment priority to the operational creditor and the secured creditors. So in case there is a impairment to any of the creditors, whether financial or operational, COC may decide to dilute the shareholding of the CD, and in case they do not dilute the shareholding, they will have to record that in their approval. Then friends, moving further, section 54L talks about approval of resolution plan. If the adjudicating authority is satisfied that the resolution plan approved by the committee of creditor under subsection 4 or 12 of section 54 that we have just read, subject to the condition provided there, meets the requirement of subsection 32. So subsection 32 says that the plan should be by the eligible resolution applicant who is eligible to file a resolution plan under section 29A, and the resolution plan provides for PPIRP cost, and the resolution plan provides for the payment of operational creditor as per the mechanism set out under section 53(1). So within 30 days, now 30 days are given to the adjudicating authority to decide whether to accept or reject, whether to pass an order for approval or to reject the resolution plan. Provided that the adjudicating authority, before passing the order of approval, satisfy itself that this plan has the mechanism that it can be effectively implemented so that it is feasible. So they will ensure that the plan is feasible. The order of approval under subsection 1 shall have effect as provided under subsection 1, 3, 4 of section 31, which shall mutatis mutandis apply to the proceeding under. So again, subsection 31(1) says the plan approved plan shall be binding on CD and other party, even the government, and the approval, after approval, moratorium shall cease to exist, and RP to forward all the records to the board, and resolution applicant shall obtain all the necessary approvals within 1 year. So this section 30 subsection 1, 3 and 4 shall apply in this case, in case the plan gets approved by the adjudicating authority. Now friends, where the adjudicating authority is satisfied that the plan do not conform to the requirements, then it will within 30 days reject the plan and pass an order for completion of this PIRP process under section 54M. Now this is important, friends. It says notwithstanding anything contrary contained in this section. Now if the application has been filed under section 54J, so 54J's talk about that in case there is a fraudulent activity by the management and the control has been passed to the RP. So in this particular case, the resolution plan approved by the committee of creditor either under section subsection 4 or subsection 12 of 54K does not result in the change of the management or the control of the corporate debtor, then adjudicating authority shall reject the plan. Now what will happen in suppose in case there were fraudulent activities and the plan came later on after the passing on the management to the resolution professional. So COC approved the plan and it is submitted to adjudicating authority. Since adjudicating authority has filed the order earlier that the management shall rest with the RP because the management or the promoters of the CDs are doing fraudulent activity, so it will make sure that the control now shall not vest with the promoter again. So it will make sure that the plan which is approved by the COC result in the change in the management of or the control of the CD, or in case there is no such thing, it will reject the resolution plan and terminate the Prepack insolvency resolution plan or pass an order of liquidation in respect of corporate debtor, declaring that the Prepack insolvency resolution process cost shall be part of the liquidation cost. So here in this case, if the promoters are doing some kind of fraudulent activity, so we will not allow them, we will not give any chance once again to them, even if the COC agrees to their plan, then also the adjudicating authority will not accept that plan in this case. Then section 54M talks about appeal against the order under section 54L. So appeal can be filed against the order of the adjudicating authority only on the grounds laid down under subsection 3 of section 61. So subsection 3 of section 61 lays down certain grounds which are the contravention of provision in case the adjudicating authority files any order which contravenes the provision, there are material irregularities or OC debts were not provided for, or PPIRP cost not provided for, or plan does not comply with the directions of the board. So only in this case the appeal can be filed under the order. Then friends, we have section 54 and termination of prepacked insolvency resolution process. So where the resolution professional files an application under proviso to subsection 12 54K. So under 54K 12 the COC will approve the plan. Under proviso, if they do not approve the plan, RP shall file an application. So if RP file an application, or under subsection 3 of 54D, so subsection 54D says that where no plans have been received, so adjudicating authority within 30 days of the date of such application terminate the process or provide the manner of continuation of proceeding initiated if any under the avoidance transaction. So how the avoidance transaction proceedings will move further, so it will pass an order. Where the RP at any time after the prepacked insolvency commencement date but before approval either under section 4 or approval of base plan or the competitive plan under subsection 12 intimates the adjudicating authority that the COC is not willing to continue or willing to terminate the process with a vote share of 66%. Friend, it is important to note here that here in this case, COC with 66% vote share can terminate the pre-pack insolvency resolution process. However, in case of CIRP, application can be filed for withdrawal of CIRP process under section 12A with 90% of the COC members agreeing to that withdrawal. Now, adjudicating authority can pass an order under subsection 1 for termination of this process, or if the adjudicating authority files an order, the corporate debtor shall bear the cost of CIRP. So whatever cost has been incurred so far, CD will bear that cost. Now, notwithstanding anything contrary contained in this section, if section 54J order has been passed earlier by the adjudicating authority to pass on the control to the RP, then adjudicating authority shall pass an order for liquidation or declare that the pre-pack insolvency resolution process cost to be part of the liquidation cost. Now friends, moving further, section 54 or talks about initiation of CIRP process in case the PPIRP process fails. Then COC with a majority of 66% may file an application and initiate the CIRP process. Now, CIRP process can only be filed in case of a corporate debtor is eligible. That means the default is more than 1 CR, and if the application is filed to adjudicating authority within 30 days, terminate the pre-pack process and initiate the CIRP process, and appoint the RP as an IRP of the process subject to his written consent, or may write to the board or may appoint some other in case this particular resolution professional is not willing to act as an IRP, and declare the pre-packed insolvency resolution process cost to become the part of CIRP cost. So in this case, CIRP process will initiate and the RP, if that become the IRP or any other IP, will take charge of the assets, and this process will be construed as if the application is filed under section 7. So as if the application is filed by the financial creditor. The CIRP process shall commence from the date of such order. From the date of order of NCLT, the process will commence, and the avoidance transaction which were pending or which were filed earlier will continue. And all these section insolvency commencement date shall mean the pre-pack insolvency commencement date. So the time taken in the pre-pack shall also be included. For determining the avoidable transactions. Then friends, we have last section of this chapter, which is section 54P, application of the provision of chapter 2, 3, 6 and 7, which shall mutatis mutandis apply to the pre-packed insolvency resolution process. So that's all in this chapter under the pre-packed insolvency resolution process. Under the code chapter 3A we have completed with. In our next video we will talk about the regulations, and we will talk about the pre-pack insolvency resolution process in more detail, because whatever has been specified under the code has been developed in the regulations. So that is a more detailed version of this code, this chapter. We will talk about that in our next video. Till then, stay tuned and take care.